To see how these agencies interact, we'll describe the process that someone goes through when they commit a crime. The police investigate at that point. The person, the violator, is a suspect. The police investigate the crime. If it's a misdemeanor, it's often a crime that's committed in the presence of the law enforcement officer. If it's a felony, it's a probable cause crime where the officer has to develop evidence that shows the suspect more likely than not committed that crime. The suspect is then arrested, which now involves a prosecutor. The prosecutor is the lawyer for the government who decides what the suspect will be charged with. The first time that the charges are read are at an arraignment. Now, this is the gateway to the court system. Where the suspect is now a defendant. To discuss the relationship between these components of the criminal justice system and someone who is suspected of committing a crime, we'll now discuss the criminal justice process. Law enforcement, or the police, investigate violations of law. These violations can include misdemeanors and felonies. The difference between a misdemeanor and felony is the minimum and maximum sentencing. The maximum penalty for a misdemeanor is a year in prison, where a felony is often a year in prison is the minimum sentence. The police, if they observe a violation in their presence, such as a misdemeanor, can make an arrest on the spot. At that point, the suspect is the person alleged to have committed the crime. When you get on into probable cause misdemeanors and felonies, the officer must establish probable cause. That is, more likely than not, that the suspect committed that violation or committed that crime. So once the police develop that probable cause, or they observe the violation in their presence, they can then arrest the suspect. From there, they have to involve a prosecutor who represents the government in front of the court. For a felony, the suspect, who will become the defendant in court, must be indicted by a grand jury. The prosecutor presents evidence, which often includes an officer testifying in front of the grand jury. If the grand jury finds probable cause, they will issue a true bill. The suspect will be indicted. The first time that they are officially read their charges, which are decided by the prosecutor, is at their arraignment. That begins the process for a trial in front of a judge. As we mentioned before, magistrate judge in the state system would have jurisdiction over misdemeanor violations, and in the state system for a felony, it would be a circuit court. On the federal side, both would wind up in U.S. District Court. If it's a lesser violation, such as a misdemeanor, it could be heard in front of a magistrate judge. If it's a felony or higher misdemeanor, it would go in front of a district court judge. So at the burden of proof at these different levels, as a suspect, the police have to have probable cause. Probable cause is specifically mentioned in the Fourth Amendment of the Constitution. This is what protects people against unreasonable searches and seizures. At the court level, a defendant has to be proved, his guilt has to be proven beyond a reasonable doubt. Once a defendant is convicted, they're remanded to, they are sentenced, and they're either remanded to prison, given a fine, some other disposition. And that takes us to the last part of the process, which is conviction and sentencing, and that sends the person into the last part of the system, which is probation, parole, and prison.